My name's Daniel Cole. I'm a intellectual property lawyer with the Olive Law Group in Cary, North Carolina. I work with entrepreneurs, small companies, large companies, do generally patent and trademark work. I've done also some kind of contract analysis and business formation as well.
Okay, excellent. So can you tell me a little bit more about the businesses, the type of businesses you work with? If there's a specific industry or type of business that...
Sure. My background is in biochemistry. So I spend a lot of time working with startup pharmaceutical companies. I've done work though I have a drone client. I have a CBD oil client. I have a client who does computer programming type things. So a broad different range that keeps it fun and interesting.
Okay, but decently tech from what I'm noticing.
Yes,
biotech
tech
and
tech
other
and
tech.
biochem and these sorts of things generally, yes.
Okay, so let's start with why do people come to you? When do they come to you, and when they come to you too late?
So they come to me when they think they have an idea that they want to protect, when they have a company name that they want to protect, and when they're trying to first start a business. That's when they come to me and they're doing it correctly. When they come to me too late, they've tried to trademark something on their own and they've received something from the Patent and Trademark Office saying, we're not going to let you trademark this name. They've tried to patent something and write their own patent and they receive an office action and they don't have any idea what the office action means. Or they come to me when their business is breaking up and they're trying to decide who gets the rights to the name or the invention. And that's when they've really come to me, the wrong person, because I don't do litigation, and at the wrong time, because all of that can be taken care of beforehand if you do your contracts and your LLC formations or your corporate formations well.
That's excellent. So I'm actually going to focus on that with you.
Okay.
So one of the things that obviously is a concern for some entrepreneurs, and one of the reasons why they try and do it on their own and not pay you your dues,
right,
is obviously a cash flow issue and being cost conscious.
Right.
So in terms of getting advice to know what is protectable, what isn't, what kind of questions should they be asking? Because, okay, let's say you either provide a free consultancy or you charge for that first consultancy. Either way, there's value there, right? And the whole point of it is that leads to other value.
Mm-hmm.
But I have you here, so I'm going to try and get some free consultancy for you, right?
Sounds good.
I'm being cheeky, but you get to get free marketing, so it's a fair.
That's right. It works out.
So let's go with what should they ask you, and what should they come prepared with to get the most value out of that first consultation.
So, and a lot of times people come, and especially when they're inventors, they come and they don't want to tell me what their invention is, which I understand because they haven't signed anything with me yet. They're afraid I'm going to like take their idea and make it my own or something. I don't know. But that is the worst thing you can do. And, you know, I've signed non-disclosure agreements before with clients. I really don't have to, because it nationally, since patent law is national, and certainly in North Carolina, I am ethically bound that anything a client or a potential client tells me is something that I can't use or I can't tell anybody else. It's privileged. It's right from the beginning.
Even if I'm not paying you yet?
Even if they are not paying me yet. We call them what they're called then a potential client. And that's anybody that comes into the office, talks to me on the phone, sends me an email and says, hey, I'm interested in working with you. You know, sometimes I have to do it where I'm talking to people at a party and I start off by saying, okay, now what I'm giving you is not legal advice, or it's not legal advice, it's legal information. You are not my client. You know, I have this whole spiel that I have to do.
Okay, so the minute that I've contacted you in a capacity as a lawyer, not having a random conversation with you, which
Right.
you already protect against by actually giving an all-out disclaimer right there, which you're actually bound to some extent. But if I approach you in a business setting, as in I call your office or I call you as a lawyer, you are ethically bound, and basically, unless my idea is so good and I have explained it so well that you can execute on it without my help, you would be basically losing all your livelihood. You would be risking your license.
Yep. And even if it is so good and you give me everything and I run off with it, you can sue me for all the money that I make and probably win. You can sue me for the patent since you invented it, I didn't, and probably win. I mean, I would be risking my livelihood. I'd be risking my license. I'd be risking everything. And
so on that note, actually, in a way, by documenting, let's say, sending you an email with an outline, I would be protecting myself because I am in that email documenting that I have this idea, I've given the outline, right?
Right.
Not in detail, because obviously there's hacking and all this good stuff. But the minute I send you an email and I say, listen, I want to talk to you about something I figured out in this particular industry that solves this particular problem. I haven't given you anything. You can't go do it yourself. But I'm going to use COVID-19 as an example because that's what's up right on everybody's mind, right? So I figured a way to run the tests in 1 hour instead of 2 hours.
Right.
They've accelerated, right? And I send you an email, hey, I figured out how to do this in 1 hour. Anything after that, I've already kind of protected myself because I've got documentary evidence if you had to be a sneaky lawyer, which I don't think you are, and was going to steal my idea, which every entrepreneur is terrified of, even though 90% of success is in execution as opposed to ideation, and actually having the recipe for that success. But I digress. Basically, that's one way for me to protect myself and still be open to getting advice and getting a quote from a lawyer to give me hassle.
Now, and I want to be sure that I say that all you're doing there is protecting yourself from me stealing your idea. You're not protecting yourself from anybody else coming up with it individually or anybody else stealing it. If maybe somebody else stealing it, but then you'd have to allow me to break privilege and basically say, hey, they came up with this and told me on this date. So if this person did the exact same thing, it is evidence that this person stole it from them. And then you can go through the patent office and there's all kinds of things that you can do.
And still, if that other person simply solved it on their own just a week after you, and this is one point I want you to touch on, right? So we've got 2 scientists, 2 technical geniuses, 2 programmers. One's in North Carolina, the other is in South Carolina, just so we can put them up against each other, right? North and South.
Right.
And they both figure the same thing out. One of them figures it out in January, the other figures it out in February.
Right.
Here's what happens in my hypothetical. The one that figures it out in February comes to you.
Okay.
Which means he gets everything in order rapidly. The person in January decides to try and do it himself. They've both individually come up with the idea.
Correct.
The guy in January waits a few weeks, gets the letter that you mentioned. I don't know what it is, so you're going to have to educate me on it, asking for more information. Your client, the one that figured it out in February, right, 1 month after the other guy, has a streamlined process and is working with you.
Okay.
There's a guy that figured it out in January who is now contacting a lawyer in the first week of March. Is he likely going to lose that opportunity?
So, and I'm going to have to try and get away from this as much as possible because the answer is going to be it depends.
Of course, you're a lawyer. It always.
Yeah, that's the answer a lot of times, unfortunately. So what I was referring to was what's called an office action.
Mhm.
And what that means is that you've sent a patent into the patent office and they've read it and analyzed it. And it would unfortunately not be in March. It would probably be about 2 years later that they get back to you. And they send you something and say, this is not patentable. Here are the reasons why. If you want to argue with us, here's what you can do. So if the person in January sends some sort of patent into the patent office first, he will win. If he does not, he will lose. It used to be less simple than that because we were used to be what's called first to invent. We are now first to patent. So you may have heard rush to the courthouse, depending on when you're buying land, depending on how your state does it. Different states do it differently. It is now a rush to the patent office when you have an invention because we are first to patent rather than first to invent.
So his risk would in fact be if, for example, he didn't protect his entire idea correctly, if anything.
Right. The risk, right. The risk would be if he patented first, the risk would be that it's not perfected well, or he didn't disclose all of what he needed to disclose in the patent, and those sorts of things.
Okay, let's touch on that subject then.
Okay.
When we're going through a patent, and here you don't need to tell me it depends because we're going very broad.
Yep.
What are some of the things, walk me through what working with a lawyer will be like and what's important in a patent? What goes into a patent?
Got it. That I can easily do. So generally, especially if you're an entrepreneur, what I'm going to start you out with is something that's called a provisional patent. A provisional patent isn't really looked at by the patent office, and they don't analyze it and say you do get a patent or you don't. But what it does do is secure your filing date. Your filing date is the date that the patent office uses to say, here is when you invented this. Here is the date that anything after this we can't look at when we're trying to decide whether you get a patent or not. We can only look at things prior to this date. So obviously you want that date as early as you can get it. The issue is that when you have a patent, you need to disclose as much as possible in the patent. The reason being, first, you don't know what you're going to have to claim. So let me back up a little bit. Patents separated into different parts. There's a abstract, there's a spec, and then there is the claims. Abstract is generally just a summary, doesn't really do too much. The spec includes figures and a lot of description. The claims are where the most important part, because generally these really decide what it is that you're claiming, that you're trying to patent. The claims determine what is covered by the patent. The spec, though, is basically your listing. Here is what the invention is. Here is how it works. Here's how you use it. Here is the best way to use it. Here's the best way to make it. All of which legally you have to do when you do a patent. The idea for a patent is, the trade-off with the government is giving you 20 years of exclusivity for your idea. You can use it, nobody else can use it. But you are giving enough information so that after those 20 years, anybody with a general understanding of the art area, which what that means is always going to be argued about, can then make and use your invention. And so a issue sometimes is that people don't put enough in the disclosure, in the spec, about how to make the invention and how to use it, either so that when they start getting office actions, they can say, okay, actually I need to claim this, and I have that information in the spec so I can move it down into the claims. Because the only things you can put in the claims are things that are also in your spec. If it's not in your spec, you can't put it in your claims. So for example, if your invention works at 30 degrees, but at 30 degrees, you have to have it mixing at a RPM of 20. But you don't have that in your spec. It turns out somebody else has invented a way to do it at 30 degrees. You're now not going to be able to claim doing it at 30 degrees. You might be able to claim doing it at 30 degrees with an RPM of 20. But if that's not in your spec, then you put it in your claims, it becomes new matter, and you can't do that. So you're going to end up without a patent.
So basically, there's a decent bit of risk in getting it wrong if you're not
Yes.
aware and understand the
Yes.
finer details.
Yes. And when somebody tells me how much information should I give you to put in a patent about the invention, I tell them you cannot give me too much. That I can look at it and say, okay, we don't need to put this in here because it's something that everybody that's at this whatever level we're going to talk about at this art area will know. So for example, if you were in the biochem space, everybody is going to know how to grow bacteria and put specific genes into E. coli, for example. I'm not going to have to put that in there. But if you're doing something different in that makes your invention work better, or is the only reason your invention works, that I need to know. So yes, there is a decent risk of doing it wrong, of leaving something out, being a way that you're going to mess it up, so that you will end up not getting a patent or not getting it in the way you want to get it.
Understood. So I'm going to go on the counter here. When is it too early to come to?
Okay. It's really never too early, because I'm not, and I can say I will not write something when I know that what you are going to write, what I would write, would not serve your purposes.
Understood.
I can't say that for other lawyers. I can say that for probably most in reality, because it gets out to people in the community when you do that, and it doesn't look good.
Okay, so
and people have come to me and not had a full idea, and I've said, okay, you need to work on this. It's not really ready to patent yet. I would need to know if you are to the point where you can give me enough information that I could then go and make and use your invention. You need to come and talk to me. If you're still figuring things out, maybe not. But if all what you're figuring out is specifics on how to make it the best that it can be, you probably still want to come and talk to me if you're refining it. Because depending on how you refine it, that may be multiple inventions. There may be an invention for the broader thing of just doing it, and then there may be a narrower invention for your refinements.
Understood. Now, legal costs tend to terrify entrepreneurs. I don't know why, but
well, because they're high and nobody in an entrepreneurial community has money. I understand perfectly why. And it makes sense because they are. It's not cheap.
Don't worry. I was about to say I find them equally terrifying.
Okay.
I wasn't saying they shouldn't be worried, but I understand that they're high and they do provide high value. If you're patenting a solution for 20 years, right? 20 years that you can benefit from that invention financially, and it's important that that is protected. Without that protection, any larger company, and I think that the patent law is actually one of the things that gives smaller businesses, and not an unfair advantage, but what I would call a humongous advantage.
It levels the playing field.
Exactly, in competing with a much, much larger company.
Right.
Now, okay, you might wind up selling it or licensing it to the other company, but if they figured out how to do it, because you told them or someone figured it out, right? Corporate espionage, whatever you like, right?
Whatever you want to say, yep.
If they did, they cannot produce you, they cannot compete you. But at least with a patent, you are protected.
Correct.
The more they sell, the more you can claim back for yourself, so you're fine. Then you need a litigation lawyer, which is not what you do.
No, I do not do litigation. I know people who do litigation, so if you need that, I can hook you up with them, but that is not what I do. And the one time I tried, it worked terribly. So you do not want me doing litigation for you. It's not in my blood.
Okay, so let's have a little hypothetical here.
Okay. We love those as lawyers.
We've got a patent, we've got an idea. What have you come across that maybe people think is patentable, but really is not?
Okay. So I have to be a little bit careful here because the ones that I came across, I didn't write, so they're still protected.
So
Because they
okay, let me
language,
rephrase
but
that so I don't risk putting you in the wrong place. What are some of the things that make a thing non-patentable?
okay, that's easier. So something that could be a new idea, but so patents, to be patentable, things have to be novel, and then they have to be non-obvious. The rub is going to be in non-obvious. Novel simply means that it has to be new. And generally, novel in the patent legal world is the same as you kind of use it in everyday life.
Mm-hmm.
Obvious is very much not. In the patent world, obvious means that somebody with all the information that you had, all the education that you have, wouldn't have been able to come up with the idea. And a lot of times they assume that somebody has all the information that exists in the world when they're trying to make an invention. And they assume that somebody trying to solve a problem is going to bring in, and it's obvious to bring in, things from other industries. A good example, somebody was trying to solve a problem in biochemistry. The problem happens to deal with looking at making levers and the way levers would work. They would look at furniture, for example. They'd look at beds. And that just doesn't seem, these two things seem completely separate. But the idea is that an inventor would recognize that they're not and would look at them. So obvious can be a hard hurdle to get over. There are ways to get around it, and there are things that can be done. But especially right now, the patent office is getting kind of tight with what they allow to be patented. So just because something works in the market, just because something is something that people are going to buy, doesn't always mean that something is patentable. A lot of times what I do is I'll do what's called a patent search, where not only will I look at see what's out there and what's already patented, I'll kind of look at something and say, okay, is this obvious to the patent office? And that doesn't mean, even if I tell somebody that something's obvious, that doesn't mean that you shouldn't try and make it and sell it. It just means you're not going to be able to get a patent on it. I had somebody who developed and I'm going to be very broad here, developed a item that kept a baby from being able to hit a sippy cup off a table and spill it.
Okay.
They could hit it off and it would move a little bit, not move enough to spill it. That's about as much detail as I can give. The way they did it, it was, I'm not saying I would have thought of it, but the patent office, it would have been very hard to convince the patent office that somebody wouldn't have, and that it was.
Okay, so there might have been, let me see if I'm on the right track. There might have been another type of tool, right? That a liquid holding container,
right,
that when placed upon a table in a particular way would also not spill. And
right,
that's being used. So that makes it obvious because it's
right,
already been figured out in a different way. Yes, it's novel,
right.
but it is obvious if
Or
you worked
go
in
for it.
that line.
Or you're combining things that already exist and you're combining them together, but when you combine them, all they do is work in the same way they worked separately. And so that's not an invention, according to the patent office. Some of us think that's a little too tight, but the patent office does not. There are ways around that. You can say that, well, this has been a problem that's existed for a long time. Nobody's solved it. So therefore, this can't be obvious because since it's a problem that's been around for a long time, if this was obvious, somebody would have done it already. Because we like money, we all like trying to solve problems. And that would have been the line I would have had to go down, because people have been having babies, and babies like knocking things off tables since humanity has been in existence. But that's not cheap, because you have to go back and forth with the patent office for a lot of times to do that. You send them an office action, you send them an office action response, you go back and forth and you argue. And that's expensive. So that's what I tell people. It's like, I could get you a patent on this, most likely. It would be narrow, it would take a long time, and it wouldn't be expensive.
Oh,
do you want me to do this?
For you then. What's the cheapest patent that you've ever seen filed in terms of cost? And what's the most expensive? And it doesn't have to be you. Okay. So that way we're not saying you're cheap or expensive or anything like that. We'll let them come get a quote for you depending. Yep. I would imagine you would reasonably tell me it depends.
I would, yes.
So
the cheapest patent is going to be something that is extremely novel, extremely new, that's unlike anything else that is out there. That is like, a bolt from the blue. The first guy who developed PCR, which is polymerase chain reaction, which is a biochemical. It's DNA, and it's a way to amplify DNA with a particular structure if you're looking for a particular mutation.
Oh, wow.
So it's a real technical thing. So I probably should not have used that as an example. I apologize.
No, that's fine.
The first 3D printers. That was a very new idea, that you're going to take a printer and print plastic rather than ink and develop an actual 3D structure that will be the same way if you manufactured it any other way using a printer type setup. The first of those patents was very broad and was, I would suppose, probably pretty cheap to do. I don't know. I didn't do those patents. The most expensive patents are going to be things where you have what we call a crowded art area, where there's a lot of other things out there. What you're doing may very well be obvious and new and improvement and make it better, but that's going to be expensive just because there's a lot out there. There's a lot for the patent office to look at. They're going to see things and find things and argue with you about whether you should or not get a patent or not.
Okay, so if it's novel and non-obvious, for you, that's going to make life easy because you shouldn't find a patent in there
Correct.
that could possibly compete with it. So your patent research is going to be easy. But Correct. If I figure out a new toilet paper,
there's a lot of stuff out there, yeah.
Right? Or a new toilet or a new car tire changing tool. Right?
Right.
There's probably already stuff out there and it's already being done one way or another.
And it always depends on the specifics. I mean, I've written patents that are improvements to new things that already exist. And if it is a fairly non-obvious improvement, or especially if it's an improvement that other people said wouldn't work, if you can find me something that says, people have said with knowledge in the area, this won't work, and then you find a way to make that work, that's a real good thing for me to say to the patent office. Hey, actually, this person that's an expert in the area said this wouldn't work. Actually, it does. Here's how we made it work. That makes something non-obvious.
Okay, interesting. I'm going to give you a hypothetical for fun, and don't worry, I haven't built this. I haven't created it.
Okay.
So we don't have a problem.
I would hope you not tell me about it in an open forum like this if you have, because I'll say as soon as you tell somebody about something, you lose all patentability in Europe, and you only have a year to patent it in America. So
that is interesting, right? In Europe, if you have an idea and you release it to the public, you actually cannot patent it.
Correct. You lose all rights in patenting at that point. In America, you have a year where you can patent it in America because patents are separate per country. And that's one thing I want to say, because a lot of people think there's this thing called a worldwide patent. That does not exist. Patents are per country, and the laws are different for every country. So if you want to get a patent in America, that's not going to protect you in Britain, China, and Japan. You would need to get a patent in Britain, China, and Japan.
I was going to go ahead and go down my amazing idea route, but I'm going to touch on this topic that you're covering first.
Okay.
So let's say I'm an American inventor, right? I create the most amazing invention.
Okay.
But I don't register it in Europe when I file for the patent.
Okay.
I've got the patent rights in the US.
Okay.
Can someone in Europe just go and do their thing?
And sell it in Europe? Yes. They cannot sell it. They could not import it into America, and they could not sell it in America.
So that's one of the problems I would imagine in pharma and biochem, that they have to kind of, before they release something to protect themselves, they have to file everywhere that they think they might be selling it.
Correct. And a lot of times they don't. You know, they won't patent in Ghana or, you know, Iraq or North Korea or places like this. But yes, they patent in Europe, they patent in America, they will patent in places like Brazil, India, a lot of kind of the first and second world.
So on the counter, if I'm an American inventor and I create something, right, and I patent it in the US, and someone in Europe decides to look through the patent office files in the US, he can just go ahead and
now
invent it?
He can't invent it, because you'd be able to say, no, I invented this and prove it, but he can make and sell it. What you'd be able to do, and patenting is a long process, which is bad, but also good. It's bad because you don't get an answer anytime, like especially nowadays, people expect things right away, and that just doesn't happen. Your first office action comes back in a year to 2 years. It might take you 5 to figure out whether you actually have a patent or not. But during that process, when things are still pending, you can still go and when you patent something, you have limited amounts of time where you can then go and patent in other countries and kind of call back to your original patent. So a provisional patent gives you a year where you can then file a utility patent or a PCT. A PCT is it protects you in any country in the world. It gives you time to decide which countries you might want to patent in.
Okay.
It generally gives you 30 months.
And that's part of the whole patent pending. And also, if I didn't know law and I didn't know patenting, I probably wouldn't know about that. And I might just file my patent with the US Patent Office. And that wouldn't protect me unless I had a PCT, which would protect me worldwide.
It doesn't. So I want to be real careful. So it's not, a PCT is not a world patent, because those don't exist. It gives you the right to say, I am considering patenting this in several different countries. If you start making this and using it when I do patent it, and if I do patent it in your country, I have the right to come after you. So it gives you 30 months to say, okay, now I'm going to go, and then at the end of this 30 months, I'm going to choose various countries and I'm going to patent in those countries.
Okay, and that's kind of part of I would imagine, part of a U.S. trade agreement in a sense with those countries.
Yes, it's a patent cooperation treaty.
Okay.
What PCT stands for, and it's part of TRIPS. It's part of a bunch of different worldwide trading treaties that are fun to read about, and the World Trade Organization does a lot of things with arguing about whether countries are actually living up to those treaties or not.
Okay, wow, that's actually very, very, very interesting to me, especially as I'm a Euro-American. I've lived on both sides of the pond, have businesses on both sides of the pond, so I find it very interesting, actually. One, it makes me understand the healthcare industry a little better in a sense. Now on to that whole patent pending thing, right? We understood how expensive a patent can be. Fair enough. How much is a patent pending? You know, I mean, to have some level of protection or to have that PCT, what do you expect?
So the range can be anywhere from 3 to 7 to 10, even for a PCT or a provisional, depending on who you go to, what art area you're in, how complicated your patent is. Do you need a lot of figures? Do you need a lot of searching beforehand or not? What I do with my clients, since a lot of my clients are entrepreneurs, is I do the search, and then I will do a provisional patent. The provisional patent, I write it in such a way that I can generally just use that as a utility patent with very few changes. And the provisional patent allows them to tell people who might want to invest with them, along with the patentability study, look, this is patentable. I have this patent lawyer who says it's patentable. Here is why he thinks it's patentable. I have written a provisional patent. Here is the provisional patent. If you invest, I can then go and patent this and protect it in America and these other countries because I want to sell it in these other countries for whatever reason. And
yeah, I'm going to zero in on one big thing, at least one big takeaway I'm taking.
Mm-hmm.
If going with the title of when should you contact a lawyer,
mm-hmm.
I'm going to go with this. If you have a patentable idea, you probably should definitely talk to a lawyer before talking to anybody else about.
Oh yes, definitely, yes. And the other thing I can do is if you have an idea that is not patentable yet, but you want to talk about the idea with other people, with investors, or with other people that you might want to work with in developing it, you can write what's called a non-disclosure agreement, which is I'm going to tell you this, you're not going to tell it to anybody else for a certain amount of time, or until I tell you can. If you do, here's what happens.
And I can have all the damages that
exactly. And
the only problem there is obviously also you've got to be careful who you tell it to, because you can say, I will charge you all the damages of this idea being used by someone else, but if that idea's value is 40 million,
right,
for example, but the person you have the NDA with entire personal assets are $500,000. Right?
Yes, exactly. Then you run into issues. And you would have to go to court and enforce the NDA, and that has its own charges and its own issues. So, yes, not talking about it too is the best way. It's not always the most feasible way.
I hate to be the guy to do this, but if you have a really good idea and you figured something smart out and you haven't talked to a lawyer yet, shut up.
Yes,
I hate
generally.
to be the guy to say it, but you're excited. You want to tell everybody about your idea and your solution, but probably the one reason you should talk to a lawyer is so that that zipping it is probably the smartest thing you can do.
Exactly. You do have a year from disclosure in America to patent it in America. So if all you care about is the American market, then you're okay. But if you want to sell it in Europe, and if it is this great, huge, wonderful thing as you think it is, then you probably should sell it in Europe. Don't talk to anybody. Talk to a lawyer first.
I was going to tell you about my brilliant idea of a robot that comes out and changes my tire. And I was going to ask you if this robot, right, pretty much had nothing unique about it.
Okay.
Now, by nothing unique, I mean, it's a robot that already exists. For example, it might be used to manufacture cars, right? But now I'm using it differently.
Okay.
I've also modified it in a way where I've added another piece of technology to it, which allows it to hop out of the back of my car. Okay, very, very cool. I've used some other interesting technology. It's got camera technology on it, but that already exists in fun robots like the Roomba and so on, so that it can figure out how to get to the wheel of my car.
Okay, yes.
And it's got little arms that come out, and it zooms in and unscrews, and it does its thing. It changes my tire. Is that probably patentable? And I don't really have this idea.
Understood.
If someone wants to build it for me, I'd be
happy.
That
would be great, yeah. I'd love to have that kind of thing. The answer is going to have to be I would need more information. I'd have to go into the details about what is the technology that you're adding to it, what is the technology used for already, how are you adding to it, and how are you modifying it. Those kind of specifics are incredibly important.
Okay, so what would be the biggest detail? I am making this point abundantly clear. All these things already exist.
Okay.
I have pretty much just taken a bit of glue and put them together.
Okay.
Now, in terms of potential for patentability, I know it depends, but I'm trying to understand, because earlier we discussed whether it's novel, whether it's obvious.
Not obvious, right.
Right? So to me, a lot of those things are obvious. Robots exist. Robots could change your tires.
Right.
What is the potential for patent? And I'm not going to hold you to this, and no one's going to hold you.
Well, all of this is legal information, not legal advice, just so you can't hold me to it. But the biggest thing would be the specifics on how you're attaching the things together, where you're attaching them together in a way that is already known. Could they be attached together easily, or did you come up with something that made them attachable that wasn't around before? Did you have to do something differently to make all of them work together in the way that they would need to work together to change the tire? If the answer to those questions is yes, that makes it more patentable. If the answer to those questions is no, then that makes it less. But there is, and especially in the biochem space, you can patent new uses for old things. For example, aspirin was used to cure pain for a long time. That was all it was used for.
But not as a blood thinner.
That's exactly. You knew exactly where I was going. Right. But not as a blood thinner. The person who discovered it could be used as a blood thinner. I don't know if they did, but they could have patented it for use as a blood thinner. Good luck enforcing that. Because I could go to the store and buy aspirin, and I don't know if I'm using it as a blood thinner or not. The issue would be you can stop other people from marketing it and trying to sell it as a blood thinner. You would be the only one who could write on it aspirin for blood thinning.
Okay, very interesting. And there's a reason why I was playing this mental game with you. Right?
I understand.
There was a purpose, and I'm going to get to the purpose.
Okay.
I am of the belief, and I want your opinion as someone that understands this. Once again, legal information, not legal advice.
Exactly.
I'm clear on this. In your opinion, do you think, this is my feeling, my intuition, if you like. I think there's a lot of things that could be patented that people take it for granted that this is maybe obvious. So kind of like my idea of a robot that can change your
right.
and so on. Right. And okay, maybe the idea of a robot that changes your wheel isn't patentable, but the way you've connected the two things together, and when you split it up into what you were talking about, the spec and the different claims, right? So I might not be able to claim the whole robot, but I'm claiming the pieces in between that would take someone years to figure out.
Exactly.
As an example.
Yep.
And that's what's really patentable in that case, because someone else can build another robot that can do the same thing.
But doesn't use those particular connections. Right.
Right. And I'm going to ask you to elaborate on the different types of patents, and that will be where we close off.
All right.
So with that in mind, do you think, and once again, legal information, not advice,
right?
There is a considerable amount of people that have a patentable idea and don't patent it, and a considerable amount of people that think they have a patentable idea and actually don't?
I do. And that's what makes the job interesting and difficult and frustrating all at the same time. Because a lot of times what I end up doing is somebody will come to me and say, hey, I have this great, wonderful idea. I want to patent it. And I'll look at it and I'll be like, this is not patentable, but this actual tiny little portion is. And trying to explain that to them, especially if they're a college professor with multiple PhDs, can be challenging. So I end up having to write the patent in such a way that I protect this huge, or I try to protect this big, huge thing, knowing that I'm not going to be able to. But I also really protect this tiny little thing that is actually going to be what's patentable and what they're going to be able to make money off of. And so that can be challenging, but that's the job. But yes, I would agree with your statement that there are a lot of things out there.
Brings me to my point of the entire point of this interview, which is finding a few really good reasons why you should seek legal counsel. It's not that expensive to get honest advice, because trust me, the lawyer would like you to need a patent.
Yes, we would.
However, they are ethically obliged as much as possible and reasonable, and also to protect their own reputation, pointlessly take you down a rabbit hole that you cannot achieve. Now, I'm sure there's lawyers of ill repute and lawyers of high repute. That's something you need to analyze for yourself. But you should seek legal counsel, if nothing else, just to know whether you're staring a gift horse in the mouth and not realizing it,
right,
not protecting something, or whether you're really putting a lot of energy into building a business on an idea that you can't even protect.
Right, or you can't protect with a patent. You may be able to protect with trade secrets, with NDAs, and it still may be something that you can make money off of, just not patent. And when you asked before questions you should be asking your lawyer, and good things to ask your lawyer, and to make sure that you have a lawyer that is going to be on the more ethical side. Don't ask them just, is this patentable? Ask them, how difficult is this going to be to patent? Especially if what you have is more of a business method or a computer program. I don't want to get into a whole lot of the 101 issues, but there's a huge thing right now in the patent world with dealing with things, whether something is patentable or not, based on 101. And if you're dealing with a computer program, if you're dealing with a natural product or something that could be construed as a natural product, or what's called an abstract idea, and even the U.S. Supreme Court doesn't know what they really mean by when they say abstract idea, so that gets fun real fast. I have a journal article that I've just written about all of this. It's in the North Carolina Journal of Law and Technology. It's coming out. Was coming out at the end of March, but with all the things that are going on right now, I don't know exactly when it's coming out.
If you send me the link,
yes, I will. When that comes out, I will send it to you. I will actually send you the article itself as well. I have permission to do that. So ask not just, is it patentable, but how hard that's going to be to patent, how many office actions I think it's going to take, whether you're going to have to do what's called an RCE, which is a request for continuing examination, all these things. It makes you, look like you know a little bit about what you're talking about and the patent system, so they're less likely to try and take advantage of you because they think you know something. And it gives you an idea of whether they're being a car salesman or not. And good lawyers, we're in this business to make a living, obviously, but a good lawyer should not come off like a car salesman. That's not our job and our role.
Okay, here's my question for you then. And this brings me to you mentioned a few ways to protect yourself, which was, for example, trade secrets, right? NDAs. What do we mean when we say trade secrets? Is that simply, making sure my employees don't share that with someone else? Or how do I protect myself? How do I protect the trade secrets?
Right. So trade secrets are things that that if your competitors knew would give them a competitive advantage. So that's extremely broad. And that covers things that are patentable, it covers things that are not. You have to take steps to protect those trade secrets. Like, I think the law is that you have to take reasonable steps to protect those trade secrets. And if you do that, then if somebody steals them, if somebody you takes them from your company to another company, you can sue them basically for trade secret theft. So the Coke formula is a good example. Only about 2 or 3 people in the Coke company know the actual Coke formula, the specifics of what the chemicals are and how much they are and the percentages and all these things. And I think they have it locked in a vault somewhere, the actual recipe. How much of that is marketing, really? I don't know. I've never worked for Coke. But that is reasonable protections around that formula. So if somebody broke in and stole it, they could be able to sue them for it. If you just have it like on your computer somewhere and anybody that logs into your computer can look at it, and you've never talked to your employees about, we need to not tell this to anybody, you are not protecting your trade secrets.
Understood. So even just a simple privacy and confidentiality statement in your
yes,
can make all the difference.
You want to list what that covers as specifically as you can. And those kinds, so that to protect yourself.
Interesting.
So you can protect yourself.
That would be a whole separate conversation.
It would, yes. I've given lectures on trade secrets. I've given lectures on trademarks, which we really didn't touch on here. I've given lectures on patents, and each one is its own separate beast.
I intentionally kept you away from trademarks.
Okay.
Reason being, they've recovered quite a bit, and also it's kind of, I saw an opportunity to discuss patents.
Patents, good. Yep, I am here to fill the need that you have.
And I do pronounce it patent sometimes, and sometimes I pronounce it patents.
And that is fine.
That's a Euro-American thing now. So
yep.
I use both. Now, let's have a bit of fun with this.
Okay.
Very simple. I want to know what type of patents are. So I noticed, for example, you said you can protect something in the way it is used. So aspirin was your example, right? I can use it to cure my headache, or I can use it to thin my blood. Now, from a marketing perspective, technically that person could file a patent to protect that. What type of patents are there?
Oh, okay, sure. So and I'm going to have to treat this in 2 separate ways. There are device patents, there are method of use patents, there are method patents, there are system patents. A lot of those are very similar. A method patent and a system patent, very similar. The wording's a little different. Very important generally in the computer space, which one you use. And it's pretty legally, it's illegally in the weeds when you would use one and when you would use the other. A device patent is more of a patent for a thing. You have an object and a mechanical way of something, or a new drug that has a specific chemical structure that
so
you're patenting.
My beautiful robot would need
would be a device patent, yes. A method patent is a patent on a way of doing something. And that would be the way of using aspirin to thin your blood, the way of using a drug to treat a specific disease. Give it in this amount of quantities, give it when you see these symptoms, give it when you have this disease. That would be a method patent.
So if Usain Bolt had achieved his running speed through a particular method, right? That nobody had ever run that way before.
That way, yeah. He could have patented that.
Get a method. Oh, wow. All right.
It would have been probably pretty difficult, especially in Europe, because I think Europe, and I don't know European patent law, but I think they have some laws on methods that restrict things like that, especially in the healthcare field. I think specifically you cannot patent methods of surgery. in Europe. But an example, and this is an example of that's used, and I hate it for this reason, but it's used to show that patents are sometimes too broad. That depends on your viewpoint. I'm a patent lawyer. I like patents. I tend to think they're not generally too broad, but that's kind of a self-fulfilling prophecy. I wouldn't have gone into patent law if I thought that. Are there some out there that are too broad? Yes. But in general, patents, I think, serve a very good purpose. Like we talked about before, they level the playing field between somebody with a lot of money and somebody without, but a good idea.
Okay, I need to let you finish on the different patents, but now
okay. So
I need an answer to.
There is a patent for a method of using a swing, of swinging in a swing that has gone through the patent office and been patented. So that would be an example of a method patent, and is why I say yes, that if Usain Bolt had run in a specific way, he could have made a patent on that. The other set of types of patents, there's the provisional patent, which is the one that gives you the year in the US and saves your date and your date of time. There's a utility patent, which is the one that the patent office actually looks at and says whether or not you are going to get a patent. Then there's the PCT. The PCT is the patent that this gives you protection in some extent around the world and gives you 30 months to decide which particular country you want to do utility patents in. Generally, the way I do it with my clients, they file a provisional. They wait a year or some amount of time to decide what they want to do next. Either then they file a utility or a PCT. If they file a PCT, they generally wait a little bit longer, and then they file utilities in various different countries.
Okay. Here's a big question for you, and I will actually ask you to send me those just in a list.
Okay.
So I can quote you on them.
Sure.
But here's something that immediately came to mind, right? There's a procedure, a surgical procedure, where they can go in from your thigh and put a stent in your heart.
Okay.
Right? The stent, the technology, let's forget that technology for a moment.
Okay.
What you're saying is that in Europe, that wouldn't be protected.
I am not sure. I am not a European patent attorney, so that's not something I know about for positive.
But, okay, let me rephrase that. In the US,
you could patent
legal information, right? Not legal advice. Something like that, you could patent.
Yes.
Wow, okay.
If it is novel and non-obvious and useful and all the other things that you need.
Okay. It's been fun.
Yes, it has.
Is there anything that you really think maybe we didn't touch on that you'd like to make sure our audience takes?
No. Come to your lawyer as soon as you think you have an idea that is fully formed that you think is protectable or you would like to try and protect. Also, if you are wanting to do something and not seek protection on it, but you're worried that you might be breaking somebody else's patent, that you may be infringing on somebody else's patent, that is another good time to come and talk to a lawyer. Because we can do research and say, yes, you're going to infringe on these patents if you do this, or no, you're not, because these patents are invalid for whatever reason. That's another side of things that we can do.
Okay, so I'll add a piece to that. Even if you think you cannot afford a lawyer right now, you cannot afford a full patent, or it doesn't make sense, you don't want to risk that expense, you can most likely, definitely at least afford getting advice as to whether you've got something protectable or not protectable, whether you're infringing or not. So while you might...
Whether you're infringing or not, if you have a particular patent you want me to look at, that you can probably afford. If you just want me to look at all the patents that are out there, that's going to be expensive.
Yes.
But yes, you can afford to come and talk to me for 30 minutes to an hour and get some information about what you might need to do next.
Exactly. That's what I'm trying to convey. You know, in most cases, you can actually get legal advice, sound legal advice, to a certain extent, to at least know whether you should be looking deeper.
Correct.
Whether, you know, and how urgent may be needing.
That may be, yes.
At the very least.
Mm-hmm.
Okay. Thank you so much.
Thank you.
I think we've covered most of it.